So the first day of hearings in Trump's classified documents case has come to a close. Trump lawyers making arguments to dismiss the case due to what they say is the unlawful appointment of Special Counsel Jack Smith. The argument they're making is that the Attorney General Merrick Garland lacks the constitutional authority to appoint Smith and that a special counsel must be appointed by the president and approved by the Senate. That's the Appointments Clause. Joining me now is lead counsel for the National Legal and Policy Center, Paul Kamenar. Paul, do you buy their argument?
Oh, absolutely. It's the same argument I made when I challenged Robert Mueller here in the D.C. Circuit in the Russia hoax case. And the argument there and the one being made in Florida is very simple. Under the Appointments Clause, all officers are to be appointed by the president and confirmed by the Senate. It does have another clause that says, however, inferior officers can be appointed by the head of the department if the position is, quote, established by law. So there has to be a law somewhere setting up the office of special counsel. Our position is that Jack Smith is a super U.S. attorney. All U.S. attorneys are appointed by the president and confirmed by the Senate. This guy can indict Trump in D.C., he can go to Florida. No other U.S. attorney can do that. So he's got to be appointed in that way. But even if you buy the government's argument that, oh, no, he's just an inferior officer and that he's really under the thumb of Merrick Garland, well, then where's the law that says you can have that position? There is no law there. And therefore, Judge Eileen Cannon took this case very seriously in about 3 or 4 hours worth of argument.
Oh, and she's getting crushed because of it, of course, by the left. Watch MSNBC.
Yep, yeah, she really is, and it's despicable. They said, well, she shouldn't even have a hearing in this case. Are you kidding me? This is a serious constitutional question. The chief judge in D.C. gave me a hearing. Another judge also gave another defendant a hearing in this, and we argued in the Court of Appeals with the hearing. So to say that she should have just brushed this off her plate is just ridiculous. And I hope she rules in favor of Trump. It will then go to the 11th Circuit and maybe just go straight to the Supreme Court, because this is a major issue that has to be resolved that affects Jack Smith's authority in Mar-a-Lago as well as in D.C.
But let's go backwards. Has the precedent been set through the years on special prosecutors, special counsel? Is the easy out that, okay, this wasn't challenged in the past and it is what it is and it stays?
Yeah, that's a frivolous legal argument. Just because something was done unconstitutionally in the past doesn't mean it makes it constitutional today. Here's the big issue. We had an independent counsel law that Ken Starr had. It was the Independent Counsel Act. That expired in 1999 because Congress, both sides of the bipartisan, said, we don't want this law anymore. Both sides get unfairly attacked by the independent counsel. So what happened? It expired. The very next day, Janet Reno dashed off some regulations, says, well, who cares about Congress? I'll just write some regulations saying that I can appoint a special counsel. Give me a break. This has to be done by Congress. There's been no real decision by the Supreme Court on this. The other side cites the Nixon case, which the court ruled about the Nixon tapes, didn't even address this issue of the special counsel authority there. So this hasn't been decided. It must be decided. Now, don't forget that, for example, in the Hunter Biden case, David Weiss was a special counsel, but that's fine because he was already an appointed U.S. attorney. Merrick Garland just gave him a different hat to wear. That's fine, but here they plucked Jack Smith off the street. They may as well pluck Taylor Swift off the street and said, hey, you're now a special counsel. It's ridiculous.
Because they are so funny and we love to watch the entertainment on MSNBC, let's play a clip from MSNBC.
None of this is necessary. When you go to a meeting and you say that meeting really should have been an email, this is a hearing that really should have been an order, a summary order that was just denying Trump's motion. So why this district court judge thinks that she would have a different interpretation when the Supreme Court has already addressed it and appellate courts have already addressed it is beyond me.
How dare a district court judge take this up, Paul?
It's beyond me that that person is an attorney. The Supreme Court has not addressed this, and only one D.C. Circuit Court has addressed this. This is still open territory here for some judge to have some gumption and rule in favor of the Constitution, and let's take it up to the Supreme Court.
Paul Kamenar, appreciate you coming on tonight.
You bet, anytime. Thank you.